before we begin, we have a pretrial motion, and can I have the introduction of the people who will be making that argument?
Good evening, Your Honor. My name is Leah Widener, and I will be giving the pretrial argument for the prosecution.
Good evening, Your Honor. My name is Joshua Gillis. I will be giving the pretrial argument for the defense.
Excellent. All right, if there's no preliminary matters, you can be seated. This is the defense motion, so we'll hear from the defense first, Mr. Gillis. Whenever you're ready, counsel.
Your Honor, by way of background, Jamie Hayes is a college student who studies at Central Coast University. On May 15, 2014, Ms. Hayes was accused of murder and interrogated by Detective Terry Thomas. But this wasn't just any interrogation. She was held in an interrogation room for 16 hours without any sleep, unable to contact the outside world, and under the nearly constant watch and questioning of Detective Thomas. Over the course of the investigation, she missed several meals and was given nothing to eat but a few stale crackers and a glass of water for the entire 16-hour period, starting at 1 o'clock a.m.
Let me ask you this. Did she ever ask for food?
No, Your Honor, she did not specifically ask for food, but given her mental condition and the fact that it was after midnight, it's unlikely that she would be thinking about that at the time.
Okay. If she didn't ask for food, or presumably she didn't ask for a break or a chance to go to sleep either, is that right?
No, Your Honor, she did not.
If she didn't ask for food, then why would it be incumbent on the police to give her those opportunities? She's not asking for it. Why would they think she needs it?
Well, Your Honor, if the police were trying to get it out of her fairly and are trying to ascertain the truth from her as opposed to simply getting what they wanted to hear, then it would be prudent to them to make sure that she was in the right state of mind to give that freely. Versus, however, since she did not ask for it and the police were not providing that for her, she wasn't in the right state of mind. Because, Your Honor, if someone is incompetent in such a way that they can't think enough, they can't make the decision that they need assistance because they are at that time incompetent or exhausted, then it's not their fault whether or not they don't receive that help. It's the duty of the police officers who are trying to have them in the right state of mind to provide them with that.
Okay, so maybe we can all agree that it would have been best practice for the police to give her a break or food, but does that mean that their interrogation was unconstitutional? Where do we see the line between best practice and what makes this unconstitutional?
Well, Your Honor, there's actually a case that ties into this specifically, and this is the case of, give me a second to find it. Right at the back, of course. Ashcraft versus Tennessee. And in Ashcraft versus Tennessee, the defendant was interrogated for a length of 36 hours. Now, the 36 hours is slightly longer than in our case. However, it's analogous because it was determined that the test of admissibility was that the effects of pressure, fatigue, and falsely aroused sympathy on the defendant. And it was found that a 36-hour interrogation is inherently coercive. Now, you might think that the time periods are different, and they are. But given the totality of the circumstances that Ms. Hayes, that the interrogation wasn't just 16 hours in the day, it was 16 hours starting at 1 o'clock a.m. The effects on her would have been the same.
All right, go ahead.
She repeatedly insisted that she had acted in defense of her friend Casey Vaughn's life, as Casey was being strangled to death by Lee Valdez. After 15 hours without a confession, Detective Thomas resorted to lies and threats, telling my client that her mom's boss had been notified and she would be humiliated at work if Jamie didn't cooperate. It was only then that Detective Terry Thomas heard what he wanted to hear, that Valdez got what he deserved. The question before you today is the legality of Detective Terry Thomas's coercive tactics and whether or not these tactics made Ms. Hayes' statement involuntary under the law. My client's Fifth Amendment rights were violated based on an analysis of two main factors. One, the extreme length of the questioning of Detective Thomas, and two, the improper use of lies and threats by Detective Thomas. Let's begin with the length of the interrogation. My client was questioned for an unnecessary long amount of time and deprived of sleep so that the detective could get the statement that he wanted. After 15 hours without a confession, the defendant had remained steadfast in her testimony of defense, and the detective had no reason to continue interrogating her other than to squeeze an involuntary statement from her. In the case of
Isn't that pretty common, though, that officers keep working at it for a while? They want to see if someone breaks down, right?
Yes, Your Honor. It is an acceptable tactic for police officers to continue questioning after the defendant has given even though a defendant keeps pleading innocence, and it's sometimes necessary to achieve the truth, as seen in one of our cases. But after 15 hours without a confession, this would be already in the morning of the next day, the effects on her would outweigh any possible value that would have.
Isn't there a case where someone is held for like 5 days?
Yes, Your Honor. I think you're referring to Gallegos versus Colorado.
And what was the result in that?
Well, the result in that was that a 14-year-old boy was held for 5 days without his parents, and his statements were actually eventually deemed to be illegally obtained.
Okay. What is, in the universe of cases we're dealing with, what's the longest interrogation that's found to be still constitutional?
Still constitutional, Your Honor? I have to look. I know the longest one that was found to be unconstitutional was 36 hours, but...
Well, you just mentioned one that was 5 days that was found to be unconstitutional. Right?
Yes, Your Honor, but that wasn't in it like a complete interrogation. He was simply held for 5 days.
Gotcha. The 36-hour one was basically a 36 hours straight.
Non-stop and with multiple different interrogators.
Okay. All right, well, go ahead.
All right. In the case of Ashcraft versus Tennessee, the defendant was held for 36 hours. This confession was deemed illegal due to the duration of the interrogation and the effects of sleep deprivation on the defendant. This is analogous to our case in both the circumstances of the length and the effect of sleep deprivation on the defendant. Detective Thomas played upon fatigue and sleep deprivation to get what he wanted, even if what he received wasn't the truth. In Haynes versus Washington, the defendant was held for the same period of time as in our case, 16 hours. He was denied access to his wife and attorney and only made a confession after he was informed that he could not contact his wife until he did so. In this same case, the defendant was actually told that he couldn't call his wife until he answered a confession, which brings me into my next point of the lies and threats by Detective Thomas. The second reason that my client's statement was involuntary was due to the coercion of Detective Thomas's statements. Terry Thomas used Miss Hayes' own mother. Yes.
It appears to me that the statement, his threat was pretty vague. He said, and correct me if I'm wrong, that her mom might have trouble at work. Is that right?
Yes, Your Honor.
So, is that enough of a threat to make it coercive?
Your Honor, well, you have to consider the effect that it would have on the listener, and also directly after that, Detective Terry Thomas became visibly angry and began yelling in my client's face. So that, combined with that statement, would have affected my client's mental state at the time.
Okay, go ahead.
Terry Thomas used Miss Haynes' own mother as bait in an attempt to elicit a response from her, by threatening that she might find trouble at work. My client's situation. Detective... Oh, it cuts off.
Okay.
We're at the wrong page.
Well, just keep going and,
All right.
and finish the best you can.
All right. Detective Thomas manipulated my client's sympathies in an attempt to elicit a response from her, which is the statement that he received. A case that is analogous with this is actually the case. This is the case of Haynes versus Washington. Now, in the case of Haynes versus Washington, the detective was interrogated for 16 hours, and he was actually not Haynes versus Washington.
Sorry, you have 30 seconds.
Okay, well, here we go. It's Spano versus New York. And this is the case in which where the defendant, a 25-year-old defendant who was an immigrant, was accused of murder, and his friend actually lied to him and said that he would receive troubles at work if he did not confess to the murders, which is analogous to our case with falsely aroused sympathy.
All right. Whenever you're ready, counsel.
The defense stood here a moment ago and told you that Jamie Hayes was coerced by Detective Thomas. But let's talk about what they didn't tell you. They didn't tell you that even after being read her Miranda rights, Miss Hayes still willingly proceeded to answer Detective Thomas's questions and never invoked her right to silence.
Is the analysis of Miranda different than the analysis for illegally coercive statement?
Yes, Your Honor, it is different. Being read your Miranda rights is something that is required by the police officers to do before any sort of confession. But coercion is when the police go beyond their bounds and are violating their rights in a different way by virtually forcing them to make a confession in some way or another.
Is there a relationship between the Miranda analysis and the analysis of voluntariness that we're discussing here?
Yes, Your Honor, it is. There is a correlation between them.
And what's the relationship?
Well, with the Miranda rights, it's letting them know that they have the right not to say anything. And once they've been told that, it then goes further and correlates with this consideration of voluntariness or not by looking at whether or not that right was kind of fudged over by the police and them getting the impression that, well, I really don't have that right anymore. I have to say something.
Okay. All right, go ahead.
The defense didn't tell you that Miss Hayes never asked for a break or to make a phone call. And they didn't tell you that Detective Thomas stopped the interrogation soon after she made her statement because he noticed that she was visibly irritated. Miss Hayes' Fifth Amendment rights were not violated because she was mentally sound, she wasn't mistreated during her questioning, and she wasn't coerced by Detective Thomas. Now let's start with Jamie Hayes' mental state. Now Jamie Hayes was old enough and had the understanding to make such a statement, as we can see in the case of Colorado v. Connolly. Now in this case, a mentally ill individual approached the police and confessed to murder after being read his Miranda rights. It was ruled that mental state alone cannot make an otherwise voluntary statement involuntary.
Isn't that a pretty extreme case of voluntariness, though? I mean, in that case, the person came to the police, and that was the only evidence they had of the murder at that time, right?
Yes, Your Honor.
In this case, she's basically under arrest at the time that she... Is she under arrest at the time that she is being interrogated?
I believe so, Your Honor.
So that makes it quite a different case, right? Than is it Gallegos?
Gallegos.
Gallegos. Yes.
It does make it a different case from that one, especially contrasting the two. There really isn't much similarity because in this one it was completely voluntary, whereas in Gallegos they had to hold him 5 days with refusing him communication to anyone before he would give them a confession. But as far as being comparable to this case, I would say that it's analogous in their ruling of mental state. I think that's really where we need to focus on, because there isn't an aspect of coercion at all, really, with Colorado v. Connolly. But there is a correlation in the fact that his mental state did not automatically make his statement involuntary. And that goes the same for Miss Hayes. Just because she was young and may have been somewhat traumatized by the event, that doesn't just automatically make her statement to be involuntary.
Now, Mr. Gillis didn't really bring up her youth, is that right?
That's correct.
Okay, let's focus on the things that he did say then. Go ahead.
Well, if we look to the circumstances in which she was questioned, we'll also see nothing that would make her statement involuntary. Now, in this similar case of Cunningham v. City of Wenatchee, the defendant confessed after an 8-hour confession in which he was allowed food and water as well as breaks. The officers in that case didn't threaten him with violence. As in that case, Detective Thomas gave Miss Hayes food and water as well as bathroom breaks. He never denied her food or water. He never yelled at her, and he never threatened her with violence. These aren't the...
What's your response to, I think, Mr. Gillis's argument that really the onus is on the police to make sure not only that her requests for food or water breaks are taken care of, but that they're actually engaged with what she might need so that we make sure that this isn't a coercive environment, no matter what she's asking for?
Well, Your Honor, I think we can see that engagement actually within this case, because there does need to be a certain amount of that. As we could see from the case that he brought up, which was Ashcraft versus Tennessee, a 36-hour interrogation with no sleep, and no food or water is coercive. But Detective Thomas did give her both nourishment and water. And she never asked for anything beyond that, which he could likely assume she would if she wanted more.
Okay, but he gives her like crackers and water. I mean, 16 hours with only crackers. Is that enough? I mean, in my experience, I would be lightheaded after 16 hours with only crackers. How is that enough to make sure that she's in a mental state where she can engage intelligently?
Well, I think that we have to take into account the fact that she did just come from a traumatizing experience, and at least very initially, food isn't probably going to be the first thing on her mind. Also, we have to take into account the fact that she did say that she felt uncomfortable asking him for these things. But if we look at it objectively, there wasn't a reason for her to feel uncomfortable. Detective Thomas wasn't threatening her, he wasn't yelling at her, getting in her face. He wasn't doing anything to make her think that she wouldn't be able to get food or water or breaks if she asked for it, since he was already giving these things to her.
What about what Mr. Gillis said, that he did start getting in her face and yelling at her?
Well, Your Honor, that only comes from Miss Hayes' statement. So as to whether or not that's true, we don't have both of them saying the same thing happened. So there is some conflict there. Detective Thomas never mentions anything like that.
Okay. All right, go ahead.
Now, the defense brings up the fact that Detective Thomas told her that her mother's boss could have some problems at work. He contacted her mother's boss and told her that he hoped her mother wouldn't have any problems at work. And they say that this shows he was being coercive, but that is simply not the case. Now, in the case of...
What would be the reason for him to say that, other than to try to get her to feel an external pressure to make a confession?
Well, Your Honor, this is actually a technique that's employed by the police, as we can see in multiple cases, such as People v. Musselwhite and People v.
Wasn't
Smith.
it a basically illegal technique that was employed in People versus Spano, or Spano versus New York?
In Spano versus New York, it was, but I'd like to distinguish that case from this one.
Let's do that. How do you distinguish it?
Now, in Spano, first of all, we're dealing with someone who was born in another country, had no criminal record, and an 8th grade education, and he's getting arrested for first-degree murder, so it's a pretty serious charge.
You'd agree that Jamie Hayes' charge in this case is pretty serious.
It is serious, although at the time he was arrested, she was only being charged for assault. So there is a bit of a difference in the charge there. But then next, Spano actually retained counsel, and the counsel told him not to answer any questions. But then he was taken and interrogated for a lengthy amount of time by experienced attorneys and police officers. And when he refused to answer questions, as he did because his attorney told him to, they then brought in a friend who outrightly told him that his job was going to be compromised, at risk, if he did not confess. Not only did he tell him this once, not twice, but 4 times until he finally confessed. When we look back to Miss Hayes' case, we see a situation that's very different. First of all, she has a higher education as she's attending college, been here all her life, and her mother worked in law enforcement, so she has that competency in that aspect that Mr. Spano did not. Also, Detective Thomas, as compared to these attorneys, wasn't outrightly saying, or even bringing in someone close to him that was saying, you have to confess or my job is going to be compromised. So I think that makes a huge difference between the levels of the threats and the lies that are going on there.
Okay, go ahead.
Now, in the case of People v. Smith, not only did the police confirm the defendant's incorrect assumption that it could take weeks to be appointed an attorney, but they also administered a fake test on the defendant that supposedly determined whether or not he had recently fired a gun. Now, this is blatant deception. But it was ruled that psychological ploys were used by the police are only coercive where they produce a statement that is involuntary and unreliable. And this confession was admitted.
So it's hard for me to wrap my head around this because it sounds like in Musselwhite they're basically saying, as I was saying, it's hard for me to wrap my head around this in Musselwhite because it sounds like Musselwhite is basically saying deception is not coercive unless it is, and it doesn't really give us any other guidance, and it's a very extreme case. Would you agree?
I would agree that this sort of deception is extreme in People v. Smith.
Is it People v. Smith or People v. Musselwhite that deals
I
with
was
it?
referencing People v. Smith, but People v. Musselwhite also has those same elements within it.
Okay. So, and Smith is the one where they give the fake test, right?
Yes.
Smith is a case from what year?
I believe it was 2007.
It's a California only case, correct?
Correct.
My concern as I'm reading Smith is that that maybe it's not that it's an aberration. It's not really the trend of the law. It's one California court making this one decision. How would you address that?
Well, Your Honor, I would like to compare it actually back to Spano and show how kind of the lies that are being used are different, because I think that really is where the difference comes down to the lies that are acceptable and the lies that are not. Now, as we were talking in Spano, he was basically saying, my job will be compromised if you do not sign this confession. In other words, you need to sign this confession. It's virtually equal to blackmail. Mm-hmm. Whereas in the case of People v. Smith, this lie was more geared towards kind of shaping the defendant's mind frame, not forcing a confession. They never threaten him with this lie. They just say, okay, we're going to administer a test that sees whether or not you've recently fired a gun. And it could be extrapolated that if he hadn't, the test wouldn't show anything and there wouldn't be anything to worry about. But if he had, he might want to make a confession now so that those test results don't come back against him.
I see the distinction you're making. I think it's well put. However, as I look at it, frankly, your case looks a lot more like Spano. In both cases, there's an inference that someone's job is at risk. It's maybe a stronger inference in Spano and maybe a subtler influence in your case. But how would you address that case? Why is the lie like the lie in Smith and not in Spano?
Well, Your Honor, the lie that we're dealing with in this case isn't saying you should confess because otherwise your mother is going to lose her job because of you. That's not what Detective Thomas said. Detective Thomas, as you said before with the defense, made a very vague statement. It wasn't very threatening. All he said was, I've contacted your mother's boss at work and I hope this situation doesn't cause her any problems. There's no insinuation that her job's at risk, that she's going to lose it, or that really anything is terrible is going to happen because of this. Whereas in Spano, the friend that came in had a wife who was pregnant and 3 kids. So if he lost his job, that was going to adversely affect all of his family. So the distinction I would make between these two lies is that the one in Spano was an obvious threat, but that the one that we're dealing with here in Hayes is merely a vague assertion that, just like in Smith, is kind of trying to push him towards the truth.
So the police can threaten people, but it has to be subtle.
Well, I wouldn't say that it was a threat, Your Honor. I would say that this is just somewhat of an assertion that is trying to, I would say, keep him in the right mind frame. There's not that same threatening aspect like we see in Spano or in the case of Haynes v. State of Washington, which is also brought up, where it's an obvious, if you do not do this, these negative consequences will follow.
Okay, go ahead.
Your Honor, it is for these reasons that because Miss Hayes was mentally sound, because she wasn't mistreated during questioning, and because she wasn't coerced by Detective Thomas, that I would ask you to look at the totality of the circumstances and respectfully request that you deny the motion to repress the evidence.
Thank you. All right. Rebuttal from Mr. Gillis whenever you're ready.
Now, the prosecution brought up the right to silence, and they brought up how my client could have been quiet in the interrogation, and how when she was read her Miranda rights, she could have just chosen not to speak. However, this is actually not the case, and as seen in the case of Hayes versus Washington, the defendant actually waived his Miranda rights, and the confession that he gave was still seen to be illegally obtained. And it was determined in this case that the true test of admissibility is that a confession is made freely, voluntarily, and without compulsion of any sort. As you can see in our case today, my client was under compulsion. She was, her confession wasn't made freely, and it was not obtained voluntarily. They also brought up the case of Colorado versus Colony, and they brought up the point that mental condition alone is not enough to say that a statement was retrieved through coercion. And yes, I agree, mental condition alone is not enough. But you have to look at the totality of the circumstances in this case. When you look at the case of Colorado versus Colony, you'll see that the defendant,
what would you say are the factors, just super briefly, that show your client was coerced?
Well,
in a nutshell. Yeah.
In a nutshell, all right. The 16-hour interrogation starting at 1 o'clock a.m., the exhaustion she would have had, the threatening by Detective Terry Thomas about her mother, the mental state of my defendant, as she was a 20-year-old, I believe.
So you do think her age and the lack of experience that goes along with that is relevant?
Yes, I do. I believe even though she is an adult, she's still young. She's still a young adult, and she's still not likely to understand and fully comprehend all the ramifications of what she could say and do.
Okay. Any others? You mentioned, I think, 4.
I think that was it, yes.
Okay, go ahead.
So as you can see, mental condition alone is not enough. But when you look at the totality of the circumstances, you'll see that my client was coerced, and all the factors that do play in outweigh the simple factor that was seen in Colorado versus Colony. They also brought up the case of Cunningham versus the city of Wenatchee. And the prosecution said that since my client was provided with food and water, that she had enough sustenance to last through the entire interrogation. However, in this, it was seen that the defendant was only interrogated for 8 hours. There were no lies or threats used by the officers. There was no yelling used by the officers. And regular breaks and refreshments were allowed. In the case of my client, the interrogation was twice as long. The sustenance that required was minimal, and the effect that it would have on her, since it started at 1 o'clock a.m., was much more severe. And it was for these reasons that I strongly urge you to suppress the evidence.
Good. All right, whenever you're ready, Ms. Wagner.
Now, I'd like to just use some of the cases that the defense brought up and kind of just contrast them and show how, in the totality of the circumstances, Miss Hayes was not coerced. Now, they brought up Haynes v. Washington, and I'd like to distinguish that because they were using that partially as Miranda rights, saying that even after being read your Miranda rights, if you confess, it still isn't enough. And that is true. But we have to look at the specific circumstances of this case. Now, in this case, the confession lasted for 16 hours, which is the same time as ours. But the police in this case would not let the defendant contact anyone and actually told him he couldn't contact his wife until after he confessed. This is one of those outright threats that we constantly see is not legal throughout all of our cases. But again, when we look to Miss Hayes' case and the situation she was in, we don't see such a blatant threat. Now, I also want to bring up the case of State v. Brown, just showing a case that I believe you asked which was the longest that was admitted. This actually was the longest interrogation that was found legal, and it lasted for 12 hours. It was a 21-year-old, I believe, so about the same age. They were handcuffed to the table, and just like Miss Hayes, they were allowed food and water as well as breaks, and it was considered legal. And finally, in Colorado v. Connolly, when we look at Miss Hayes' mental state, we can see that she is a college student who's attending with a full scholarship. She was valedictorian of her high school, editor of her high school newspaper, and her mother worked in law enforcement.
You've mentioned that fact that her mother worked in law enforcement a few times. What relevance do you think that has?
Well, I would say that means she has a little more background than most kids in that area. So she may, and this is extrapolating a bit, but she may have more knowledge of her rights in that area.
Now, you say it's extrapolating. There's no actual facts in the record that we have before us that she does know more, or even that she ever had any conversations with her mom regarding her work or the system. Is that right?
That's correct, Your Honor.
Okay, so we are assuming that gives her additional knowledge.
Yes,
right?
Your Honor.
Okay, go ahead.
Miss Hayes was a competent young woman who knew what she was doing when she answered Detective Thomas's questions. And it was because of this, the totality of the circumstances, that I would ask you to deny the motion to suppress the evidence.
All right.